Thank you very much. Thank you, everybody. For those of you who don't know, I am here on the con side, and I will try to keep within the time frame. The ACLU has very serious concerns about the proposal for a constitutional convention, and they are both substantive and procedural in nature. The substantive is the most important one from our perspective, and I want to start with that. And I think Professor Williams actually summed it up well at the end of his comments when he talked about how these are now policy issues that get dealt with in constitutions. And they are the issues that will get dealt with in a constitutional convention, no matter what the good faith of those who propose this convention may be. We see it now on a regular basis. The votes that the voters get to choose across the country are on some of the most divisive, controversial, social, ideological issues there are. Abortion, gay rights, same-sex marriage, anti-immigrant. We are deluding ourselves if we think we can hold a convention and not have those issues come to the fore. And in fact, as you've heard, it really is a national matter now. There are national interest groups that are interested in using state constitutions to push these controversial measures. But it's not just out of state. We also have the history here in Rhode Island. From our 1986 convention, which you've heard is the last convention that has been held in the country. What was the major controversial, divisive issue that came out of that? A constitutional amendment declaring that life begins at conception. Everybody went into that convention talking about the same things people are talking about now. Line item veto, redistricting, things of that sort. But it was an abortion amendment that took hold in that convention. And there's no reason to believe 30 years later things are going to be better. We aren't going to see anti-marriage initiatives or anything of the sort. And what's troubling about that is that we're talking about individual rights that should not be subject to majoritarian control. You'll hear about all the safeguards that are in place. First you have to elect the delegates, and then the convention has to vote to approve an amendment. And then it's up to the voters to approve or reject it. So we have all these safeguards. They aren't safeguards when you're talking about minority rights. You have a majority, both in the convention and out among the public, deciding whether or not minority rights will continue. And the fact that it's possible, after spending millions of dollars, thousands of hours of time to defeat it, that's not the answer. Especially since many of the times they aren't defeated. Most of these social amendments that have been proposed elsewhere, these ideological amendments, have in fact been approved by the voters. So from a civil liberties standpoint, we're very concerned about that. And one other thing I want to mention about 1986 and what came out of it was the abortion is the big issue. There were two other amendments that came out and were approved by the voters, both of which had a very significant adverse impact on civil rights and the rights of racial minorities. One was an amendment authorizing the denial of bail to people charged with various drug offenses. And that's an amendment that had and continues to have a disparate impact on racial minorities. A second one had to do with voting rights, and it expanded the number of ex-offenders who lost, who lost their voting rights upon being convicted of crimes. And in fact, it took the General Assembly itself to propose a constitutional amendment to undo that in 2006, and the voters approved that. But they had to do it because of a vote that came out of the Constitutional Convention. Now, I just want very briefly to talk about the procedure, because this is another, I think, tremendous and dangerous myth that somehow this convention will be above politics. This is the anti-General Assembly. We need the people to get together in order to address the problems of the General Assembly. I want to assure you a convention is nothing but a mini General Assembly. And to think otherwise is a wonderful delusion, but that's what it is. And again, I want to go back to 1986 because that's the experience we have. You heard it was a nonpartisan convention, and that was true. But let me tell you, there were 7 former legislators who won seats to the convention, including, in addition, there were relatives of legislators who won a seat, including, you'll be happy to know, both the son and sister of the Speaker of the House served in the 1986 convention on a nonpartisan basis. I think one of the more disturbing things is what happened afterwards. You heard how, well, you know, these are people who have not, they aren't accountable, they can do what they want to do because they're free from politics. In 1986, while the convention was still in session, 17 of the delegates filed to run for General Assembly seats. That doesn't include the many other people who filed to run for city council, town council, mayor. We had a gubernatorial candidate come out of that convention. And I could go into more detail, maybe when we have the Q&A, I will, about all the politics that surrounded the convention. This was not above politics. It was right in the middle of it. And I think we all need to think about, do we want to risk the dangers that a constitutional convention might pose to our rights in the hope that it will do the right thing? Thank you.
Thank you, and thanks to the Hassenfeld Institute for organizing this symposium. I was delighted to see Alan and Bob here, who played such a big role in the separation of powers amendments a few years ago, who came and testified before the legislature when those amendments were considered. And I think we all learned from their presentations, which I thought were excellent. I think the biggest reason why we need to have a constitutional convention this time around is it's been almost 30 years since we've taken a close look at this document. Almost a whole generation of folks have come and gone, and we're in a fundamentally different world than we were back in the mid-1980s when our Constitution was last subject to a convention. The internet really didn't exist as we know it now. Cell phones, texting, all the modern things that have happened in the last 20 to 30 years. We're in a new world, and so it's healthy, I think, to take a look at our fundamental legal document. The importance of the state constitution is as follows. It can't be contradicted by the General Assembly. It is, as the professors mentioned, our supreme law in the state. And so it is a way of limiting governmental power supremely in a way that no court, no legislature, no governor can contradict. And that's why it's such an important document, particularly in the limitations that it imposes and some of the things that it can address that are not likely to happen through the normal, ordinary lawmaking process. Particularly when the things that need to get done are those that are going to be diminutions of the legislative or other governmental powers, because nobody willingly gives up power. And so if the people are desirous of limiting power, it's unlikely that without a scandal or without some extraordinary events that you're going to be able to persuade legislators to voluntarily give up power, such as a line item veto or other amendments applying the ethics laws to legislators. These things are not likely to happen because it's going to be entrenching on their power. So that's why it's a good thing, I think, for the Constitutional Convention to happen. We need to take a look at our document and see what things need to be changed in light of the 30 years that have happened and the experiences that we've had. We've had a lot of things that are going to inform our judgment. The ethics amendment is a big issue, I think, as it being applied to legislators. Judicial selection issues. Can we improve upon our methods of judicial selection? John Marion, who you heard from earlier, has written a wonderful piece in the Roger Williams Law Review a while ago that talked about some of the problems with judicial selection. So that's an area that we could look at. Voter initiative and referendum is a subject that ought to be considered. I mentioned the line item veto. Should we have a right to education in Rhode Island? Some of you would be astonished to know that we really have no state constitutional right to an adequate and meaningful education. Is that something that ought to be embedded in our Constitution, or ought it to be left to the sole discretion of the General Assembly as to what sort of education. And given the changes that are happening in the world of education, adult education, technology, the need to make sure that we have people that are trained for jobs, are these things that ought to be so important that they need to be embedded in our Constitution in some way. Should there be a way in our Constitution to make it easier to have cities and towns combine and share services? It's now incredibly difficult to do that. One of the things I found in Central Falls experience was there was very little willingness at the local level for cities and towns to combine and share services and do the kinds of things that we think might be more beneficial and more economic in a state as small as Rhode Island with 39 cities and towns. So is there something we can do at the state constitutional level that would encourage combinations and sharing of services for all kinds of reasons? So there's a bristling agenda of potential to-do items that need to be looked at in our Constitution. One of the things that frustrated me as a judge greatly was a realization that the Constitution is not self-executing according to the majority of the court. What that means is that rights in the Constitution, such as the right of a victim to be heard before a sentencing judge passes judgment on a convicted criminal, is not enforceable without the General Assembly enacting legislation to implement that right, even though the state constitution provides for it. And the court said that, the majority of the court said that unless the General Assembly empowers courts to enforce state constitutional rights, they're really unenforceable just because they're in the Constitution. That to me was astonishing, because basically that gave the General Assembly a veto over state constitutional rights, when it should be just the opposite. State constitutional rights, of which the ACLU and others are great champions, ought not to depend on General Assembly blessing before they can be enforced. And so these are things that I think need to be taken a look at. You know, there's no guarantee that a constitutional convention would come out with any recommendations to change anything. It's really a question of looking at it closely and deciding whether, on balance, we ought to let the voters take a look at potentially changing some of these issues. So I think it's long past time for us to take a look at this. I don't subscribe to the Pandora's box theory that by having a convention, we're going to suddenly strip ourselves of all our liberties. When that happened in 1986, and there was this anti-abortion amendment, the voters have a good sense to pick and choose which they want to support and which they don't. Ultimately, I think you've got to trust in the good judgment of our people, and so I don't fear a convention that would be captured by special interests, or because in the end, the voters have the final say, and they, time and time again, I think have shown good sense in picking those things that they want to see happen and change, and deciding which ones are not worthy of having here in Rhode Island. So for those reasons, I would favor a constitutional convention, and I think it would be a good, healthy thing. It would be empowering. I mean, Steve Brown thinks it's a bad thing that people might, as a result of that experience, want to run for office. I mean, my goodness, that's a wonderful thing. That empower people to get excited about serving their government because of their experience as delegates. That's a great thing. I wouldn't consider that a negative at all. So I think we should do it. I hope that the Hassenfeld Institute and other organizations will get behind this, and that the voters will support it.
I rise mildly in support of the idea. For strong yes and strong no, you will hear a weak yes-ish from me. As some of you in the audience know, I teach constitutional law, that is the U.S. constitutional law, and that's my day job, so I'm kind of dabbling in this other area of state constitutional law right now. And as the speakers earlier in the day pointed out, the U.S. Constitution is the hardest constitution in the world to amend. The hardest. And that keeps me in business, because it puts all of the pressure on the judges to interpret the Constitution to allow change. That is, if you want change to the U.S. Constitution, you go to the Supreme Court. That's where you go, and then they issue a new decision, and then my casebook gets to be filled up, I get to teach it to my students, it keeps me in business. But the state constitution is a very different thing, as you've heard. In the state constitutions, the people get to decide directly, as Rhode Island is being asked to right now. So, the first question is, well, do we need constitutional change? Well, to answer that, you need some idea of when an issue is of constitutional status. I mean, for instance, I'm for an increase in the minimum wage. I want better schools. I don't want the high schools to use kneecap for graduation. But are any of these of constitutional status? Are any of those issues ones that I think we need to change the Constitution to adopt? And I would say, no, because as a general matter, the purpose of a Constitution is to entrench certain relatively permanent structural issues of rights and powers. That is, to take certain kinds of decisions out of everyday politics and make them hard to undo through the ordinary means. To try to settle certain divisive issues once and for all. And none of those issues that I've said I think are of constitutional status, but I do think that there are some facing Rhode Island that are. And in particular, there's some issues that I think are hard for the legislature to deal with, and why a constitutional convention as a mechanism makes sense rather than relying on the legislature to pass piecemeal amendments. When the legislature is either indifferent or opposed to constitutional change, that's when a constitutional convention makes the most sense. For a set of issues that would take away power from the legislature, reapportionment, fiscal reform, giving more power to the governor through the line item veto, or through judicial selection, taking away the power there as well. So for these sorts of issues, I think that a constitutional convention makes sense. Ethics reform, taking away the master lever, all of these are, I think, best handled by the people, because through a convention, because asking the legislature to do it is very difficult because it is opposed to their views. Now, in saying that, I think there's substantial obstacles to first getting a constitutional convention approved. And the first is purely citizen indifference. That is, most voters know very little about the Constitution, and when voters don't know about an issue that's presented in a ballot as a ballot question, they usually tend to vote no. So to get success in getting a constitutional convention, we need a campaign informing the voters of what the issues would be. And the work of the State Preparatory Commission is extremely important. If the voters are going to know that there's a constitutional convention possibly coming and what issues they might decide. And in this instance, you can see the legislature gets to control that. They haven't, the Senate has approved the Preparatory Commission, but the House isn't. The governor can pass one, but it's happened in the past. They created the Preparatory Commission at the last minute. Voters didn't know anything about what the issues would be, and they defeated it. Now, but even more likely, the more likely obstacle to holding a convention in the first place is a well-organized campaign by opponents. That is, in-power parties and groups that have entrenched power or power that's protected that they fear that they may lose. The legislature itself may try to co-opt the process, and these other groups that fear what may happen at convention will oppose it. In state after state over the last 30 years, they have been asked to have a constitutional convention, and they've turned them down in every case since the last one was held in Rhode Island, and largely because of opposition by the progressive coalition that I tend to support. That is, unions, teachers, people who support abortion rights, the LGBT community, and the ACLU, and they oppose it for much of the reasons that Mr. Brown has articulated. That is, they fear losing hard-fought gains, and they fear the Pandora's box that may occur in a constitutional convention. And in a certain sense, I share their views. Now, one thing, when you look at other states that have had constitutional conventions, as a general matter, the output of the conventions tend to be very moderate, very centrist. If anything, I would criticize them for not making broad, progressive recommendations. But even if they were, as we know, the voters get a second chance. The voters have to approve them. But even at the basic level, the concern that that will have a runaway convention or that they'll pass recommendations that are contrary to our fundamental rights is really a point of view that expresses simple, profound distrust of the people. That is, we can't trust the people to enact legislation that will help us. Now, and because they may take away our constitutional rights. But of course, where did all these constitutional rights come from? That is, all the, we said we shouldn't have minority rights put up to a majoritarian vote, but every protection for minorities in the Constitution was adopted through a constitutional amendment, through a political majoritarian process. These protections for minorities didn't just come down from the heavens. The people created them. And the people can, I think in general, be trusted to do the right thing. That is, the concern that people are going to be debating abortion, or going to be debating gay marriage, or debating animal rights is not something to be feared. That's what democracy is about. That is, don't we want the people to decide these basic, fundamental questions of what our society is like? Because if the answer is no, then who do we trust? And that is, who gets to decide this? We just want the judges to be deciding what our rights are? That is, but what are they basing it on? A document created by the people some time ago. So really it's just an expression saying, we trust the dead hand, we trust other people who have created these rights, and not the current generation, those of us here in the audience. I think if we were to hold the Constitutional Convention today, with this group in the audience, they would likely come out with recommendations that most Rhode Islanders would support, and if they didn't, they get the chance to say no. So, with my, caveats that I think that there's some cause for concern, I rise in general support of the idea.
So Stephen Brown said something that really hurt my ears. He said he wanted to talk some more about the politics surrounding the convention. And I asked the panelists to respond to the question, but just with one caveat. If you look at the seam of constitutional changes in the state over the last 20 years or so, the major ones have essentially dealt with balancing executive and legislative powers. Executives and general officers are given 4-year terms, separation of powers is enacted, judicial selection was modified. And those really got to the basic question of executive and legislative power. And so, and you never go wrong in Rhode Island trying to put something in a political context. So, let me do it this way. So, what I've heard, is that those opposing holding the convention argue that a focused constitutional convention, or the issues rather, could be accomplished, without holding a constitution. And they speak of the traps possibly for minority rights. And then on the other side of the scale, proponents contend that the inside establishment, primarily the General Assembly, has blocked citizens from addressing important issues. What are if those are the poles, in an oversimplified way, starting with what are the politics of trying to make reform and address the concerns on both sides?
Well, first, I think one important thing to keep in mind is that there is no magic bullet. And I think that's one of the things that underlies the support for a constitutional convention. If we have this convention, we'll be able to deal with many of the problems that the General Assembly refuses to deal with. Now, don't get me wrong. I hear Professor Goldstein talking about entrenched power as opposed to constitutional convention.
I only wish the ACLU were the type of entrenched power that he's talking about. It's actually, it's funny, but it's also troubling because there is this attempt already to demonize people who have concerns about a constitutional convention. There was an op-ed in the Providence Journal just the other day talking about the Machiavellian tactics of the opponents of a convention. You know, before the opponents have even done anything, it's already Machiavellian. And that disturbs me a great deal because the opponents are talking about this great conversation and discussion we can have, and yet almost the first thing out of the gate is to demonize those who oppose it. There is no simple solution. The legislature will always be an obstacle to certain types of reform. It requires a great deal of effort to overcome that. It has been overcome in some instances. It takes time. It takes a lot of work. And I would suggest that the effort that would be spent to elect all these fantastic delegates to a constitutional convention who will do the right thing could also be spent running for elective office instead to fix the problem that everybody says is the problem, which is the General Assembly itself.
Jerry?
Yeah, I mean, I don't, disagree that many of these problems could be dealt with through piecemeal amendments coming out of the legislature. I mean, that is, it's not either a constitutional convention or the legislative option. Those aren't the only, they're not diametrically opposed views. Yes, we could have both. That is, we can, and in fact, many times the threat of the Constitutional Convention is what prompts the legislature to issue a series of amendments that would accomplish the things that the convention would in a way that they get to control. And that would be fine with me if they, are able to accomplish the sorts of reforms that I think Rhode Island needs at the legislature that they have resisted. So I don't think that it's an either or proposition.
Yeah, I think that's a very important point that the potential of a constitutional convention can have a galvanizing effect on legislative action. Consider the separation of powers amendments. It took 10 years or so to even get those in front of the legislature and the posture that they could be enacted, but I think the threat of a constitutional convention, coupled with the scandal that the Speaker was going through at the time, was very helpful in getting those enacted. But it took 10 years and a scandal, essentially, to make it happen. So I think that that's an important idea that we still have a lot of time left in the current session. We've got a new Speaker. Consider the possibility that he might champion ethics amendments. You laugh because you say that's improbable, but it might be a shrewd move on his part to take out some of the steam from proponents of a convention, to show, just as the legislature did on the separation of powers issue back in 2004. So we'll see what happens, but the reality is that it's very difficult to get the legislature to give away power through line item vetoes, ethics amendments, making the Constitution judicially self-executing. I'm not optimistic that that's going to happen, so I think it's a very important function of conventions to be a spur to legislatures to do things that they might not otherwise be inclined to do.
I'm saying something on consensus, maybe I'm being polyandrous, but what I heard the three panelists say, that if the legislature does their job, we may not need a convention. So the question becomes between now and the end of the session in May, will the legislature do their job? And the question I have to the panel, the follow-up question, are things bad enough now where we need a convention if the legislature doesn't do its job? I see Alan Flink sitting there. The Hassenfeld Institute was named after Alan Hassenfeld, who was a Right Now coalition in the early 90s. And all the constitutional changes that I mentioned earlier came as a result of people reacting to very unpleasant situations, just scandals. So let me ask the panel, where are we right now? I can quote all kind of economic data and I won't argue with it, but we all know the situation the state is facing in a number of areas. I'll start with Bob and just work where it was. Are we there at that point now?
Well, I think, to pick up on the metaphor or phrase of the day, if you really think that things aren't broke in Rhode Island, then I guess we don't need a convention. But if it is broke, let's fix it. And there are things that I think need to get fixed, and I think a lot of people think need to get fixed. And we don't see it happening at the legislative level, at least not to the extent and with the scope that it needs to happen. So the people, I think, are frustrated by some of the things that are happening. Ethics situation is still deplorable. We're frustrated by the fact that the General Assembly has decided that they can now appoint judges essentially through naming magistrates that make an end run around the Judicial Selection Commission. So there are a lot of things that need to be addressed that aren't getting addressed, and so I think that a constitutional convention, while it's not a panacea, it's not a cure-all, it is potentially subject to risks that have been mentioned here today, but on the whole, I think it's a healthy thing, and it would be a mistake to take that off the table and just let things go on as they have been, because clearly things are not working to the satisfaction of most citizens.
Yeah, I tend to agree with it. That is, I think that there are, I think a constitutional convention would absolutely be required if there was a broad reform agenda that the legislature was resisting. That is, if there were deep structural changes that we could identify that need to be made. I don't think that we're exactly in that situation. That is, what I think is there are a series of little changes that most people agree on that the legislature might enact if pushed. So that's why I'm mildly in favor. That is, many of the concerns, ethics reform, master lever, and these sort of tweaks, or somewhat, of course, important, aren't, radical changes to our Constitution. I do think that, a convention would be one way you could likely get recommendations in favor of all of them at once, but at some real cost. That is, it may cost $2 million, and it may also, and there are risks, as the ACLU points out. But I think it would be at least an efficient way to deal with a series of small problems that we can all agree on. That is, I think that people generally in the state feel like have real strong concerns about corruption and inefficiency in government, but it's an unfocused reform agenda. That is, there isn't a coalition that says this is exactly what we need to do to make deep changes. And again, in that situation, I would absolutely think, I would not be mildly yes, I would be enthusiastically yes. But again, that's just one where I think we are.
Well, I've heard various permutations of the mantra, if it's broke, we have to fix it. And government is broke. Government is always broke in one way or another. There's a disconnect, however. Yes, let's fix it, but what is it that makes a constitutional convention the thing that fixes it? And again, our history teaches us it doesn't. We had one in 1986. Many of the government structure issues we're talking about were on the agenda then. If you look at the Preparatory Commission report, you'll see talk about bracketing governor and lieutenant governor. You'll hear talk about line item veto. Those were all on the table 30 years ago too, but they didn't happen. I do want to give just one example of what did happen in the convention in '86 in terms of substantive issues. You've heard a lot of talk about separation of powers and what a big issue that was, and a big issue it continues to be. In 1986, while the convention was in session, Superior Court Judge Ronald Laguerre, who went on to become and is a federal court judge, issued a ruling holding that legislative appointments to executive bodies violated separation of powers. That was back in 1986. And do you know what the convention did? They gave first passage to a constitutional amendment to undo Judge Laguerre's decision. So we can sit here and talk about how we're going to bring these people together and to do all the right things and fix everything, but history, experience teaches us otherwise, and I would like to suggest there are other ways, much better focused ways to try to deal with these problems than opening up what I think is a Pandora's box and potentially putting important civil rights and civil liberties at risk.
Let me follow up on that point. I don't think anybody on the panel or in this room would disagree that one of the basic tenets is to protect your minority rights, and that when you have a constitutional convention, since you can't control it, that's an issue. But is the issue changed? I look at what's happened on gay rights. I look at what the federal courts have done. I look at how quickly public opinion has changed and what federal courts are enforcing. And I go through a litany of other issues which indicate that the way we look at minority and civil rights today is very, very different as a society than the way we looked at them 10 years ago. And so is the concern about minority rights, it's always a concern, but how practical is a concern given the societal issues having been faced today?
Well, certainly some things do change over time. Some things get better, some get worse. In terms of gay rights and same-sex marriage, there's no question there's been a sea change in opinion, but keep in mind that I believe there have been over a dozen constitutional initiatives where the voters have approved banning or restricting gay rights all within the last 10, 15, 20 years. So the courts have been very helpful in that regard, but when it comes to this let the voters vote about it, it hasn't been so great. But leaving that issue aside, where I would agree there has been, in a general sense, support for a more progressive movement, you look at some of the other constitutional provisions going on across the state, and they move backwards. Certainly in terms of abortion rights, there have been a number of anti-abortion amendments in the past decade, anti-affirmative action provisions, which you heard Professor Williams mention. So yes, there's been a sea change in opinion on some things forward. From our perspective, there have also been issues where the voters have gone backwards.
Yeah, I think that the concern that what the convention or any constitutional amendment or any legislative act could do might threaten minority interests, minority rights as well founded. The people don't always do the right thing. There's no question about that. That is, they might not, and they might not do the right thing with regard to minorities in other mechanisms, not just a constitutional convention. It's not that that we should have a Pollyannish view that the people always do the right thing. The question for us, though, is this particular mechanism one that might lead, on whole, to better, to some progress for the state? One thing about minority rights to know is that, of course, no matter how far the convention went, and even if the convention were to recommend things that were harmful in limiting minority rights, and even if the people then were of the state of Rhode Island, notwithstanding the expected campaigns of the ACLU and other opponent groups, even if the people were to approve it, they can't go beyond, they can't go below the floor of the federal constitution. That is, they can't violate our federal constitutional rights no matter what they would do. So at least there's some limits on how far the people could go in making the wrong decisions. But beyond those limits, I think in general the people should be able to decide our fundamental questions. And the fear that they may make mistakes is, I think, not a good reason to limit democracy ex ante.
Yeah, I see no appetite in Rhode Island for diminishing our civil rights in any way. So I think the concern there is overblown. The votes that Steve Brown has alluded to have occurred in much more conservative states. And when, even back in the mid-'80s, when an anti-abortion amendment was put to the voters, they had no interest in approving that. So I don't see that's a real serious concern. On the other hand, I disagree with the professor here about whether these changes that we've been talking about are relatively minor. I don't think this is playing around the edges or doing little tweaks here. The things we're talking about, ethics amendments, line item veto, judicial selection changes, voter initiative and referenda. These are not minor, these are big deals. These are checks and balances against an all-powerful legislature that give the people some way of letting themselves be heard in a system that's, remember, dominated by legislative leadership. Very few people that aren't elected by the electorate at large and who have enormous power over their fellow legislators. So we've got a system that needs more checks and balances, and I think that the changes that are on the table this time around are significant and substantial, and not just minor tweaks of our system. And so I think that while I think we need those structural changes, I think there's very little risk that there's going to be any real threat to civil liberties. And even if a convention were to come out with anything like that, I think the people would have the good sense, as they did back in 1986, to not go for that.
Let me turn the question on minority protection around, and let me disclose something before I ask the question. I'm part of an effort to try to get the Constitution amendment to deal with equal educational rights. Now, the legislature ducks that because there's a chance the state could get sued. But Condoleezza Rice said the leading civil rights issue of our time is educational opportunity. And there have been fundamental paradigm shifts in what the state does in regard to educational standards, educational accountability. And we can argue about details of NECAP, but those shifts are pretty fundamental, and they're happening in other states. The legislature refuses to address that issue. So if you're concerned about minority rights, is there a shoe on the other foot which suggests that minority rights are being ignored? Well, civil rights, I should say, not minority rights, which are civil rights and basic civil right is being ignored by the legislative process, and that a convention may be the only way to right that wrong. And let me just ask the three to respond. So I'm trying to look at minority rights from both sides, what the legislature does and doesn't do.
Civil rights certainly are ignored by the General Assembly. That's why I'm up there all the time banging my head against it. But again, I go back to the disconnect, and therefore, if we have a constitutional convention, we'll be able to correct those wrongs. I don't think that will happen. I do think, as I said earlier, it does require a lot of work to get the General Assembly to do the right thing on certain matters. I don't think the Constitutional Convention is the way that these issues will, in fact, get favorably resolved. I continue to be concerned that just the opposite will happen.
I mean, I just have to repeat what I said before, that is that I think the legislature is one place that we can raise this issue of educational rights, and they may not be receptive to it, and a constitutional convention may be more receptive to it, or it might not. That it's not, that one is necessarily a better mechanism than the other. It's not either or.
I think another interesting phenomenon is a constitutional convention is not just a threat to the legislature or legislative power, but also to those who are lobbying at the legislature, because they're the ones who, this is their access. They know the corridors of power. They know where to try and press the buttons. A convention is a wild card to a lobbyist. They don't know how to deal with that issue. And so I think it's very threatening to them as much as it is to legislatures. So I think you're going to see among the folks that are opposing holding a convention is the cadre of lobbyists that now apply their trade up at the legislature. And they don't always enjoy success up there, but at least they know where to go. If we have a convention, that shuffles the deck, and the lobbyists are going to be at a loss to figure out quite how to get their 2 cents in front of a convention, because it's going to be a whole different phenomenon than they're used to in the General Assembly.
All right, just one last question. I'm getting this single. I've got 5 minutes. And use this last question to make any points that you would like to make that you didn't get the opportunity to make. Are there specific constitutional changes, regardless of the process, that you think is critical to be considered at this point? And then in answering that question, if there's anything else that you'd like to add, please feel free to do so. So I'll start with Judge Flanagan.
Well, I think I mentioned this in my opening remarks. I mean, to me, it's inconceivable that the Constitution wouldn't be enforceable by our courts without the legislature first enacting enabling legislation. And, you know, people like Steve and other proponents of civil rights ought to be concerned about that, because what that would mean is that if our state constitution does provide for example, victims' rights or other rights that are unprotected at the federal level, the judiciary can't enforce those rights unless the General Assembly passes enabling legislation that would permit that to happen. And so right now, we have an amendment in our Constitution that allows victims to be heard, but if that isn't honored, there's no way for the victim to go to court to get that right enforced until the General Assembly passes enabling legislation, which they refuse to do. So I think that's a critical provision, and one that civil rights advocates like Steve Brown ought to be totally behind. But beyond that, I think that that's maybe not as popular an issue as the ethics amendment and line item veto, the educational issue that we talked about. These are all critical issues, and no one of them is going to necessarily make a huge difference, but collectively, I think they have a chance to really take Rhode Island to a better place, and more importantly, just to think about these issues and to become educated about them and how they might affect our governmental process is a sound thing. It's a good thing for citizenry to get excited about this and interested in the process. You know, Steve is concerned about the politicization of a convention, but you know, I tend to think of it as potentially a good thing in the sense that it's going to get people excited about the possibility of making government better, of getting involved in their communities, getting involved at the state level. I think of it as a good thing. So those are my thoughts.
I think ethics reform and the line item veto and educational quality are all reforms that are needed, you know, whether it's done through the legislature or done through a constitutional convention. I do think that again, and this I agree with Mr. Brown, that constitutional convention is no magic bullet, exactly for this reason, that is the same forces that stop these reforms from happening through the legislative process and the normal amendment process will also operate at the Constitutional Convention. That is, there's no reason to necessarily think that the Constitutional Convention is likely to be any more successful at accomplishing those than the legislature, but I do think that it's a chance that we should take, because in all likelihood, it's more likely to lead to positive results than negative.
I think one of the interesting things that's come to mind in listening to this, we've heard about the importance of amending the Constitution to deal with the ethics in the legislature. Justice Flanders has rightly raised a concern about this lack of an independent right to enforce some of the civil liberties provisions in the Constitution. But what's interesting about that is both of those were amendments that came out of the Constitutional Convention itself. And it's the courts, through their interpretation, that has really stymied progress in those areas. Another one that's been mentioned is the right to an education. There are more than a dozen courts across the country that interpreted similar provisions in their state constitutions to mean there is a right to an education. Our Supreme Court has ruled otherwise. So it's fine to put words on a piece of paper, whether it's through the General Assembly, whether it's through a constitutional convention. Even when you do that, here we are 30 years later saying we need a constitutional convention in order to correct problems that apparently existed from the constitutional amendments we approved back then. So I'll end there.
Thank you.